Hi, I'm Chris Nudo from NTegrity Law. Today we'll break down the legal steps siblings must take to manage an estate successfully without unnecessary delays or costly mistakes. At Integrity Law, we've helped countless families handle estate matters, ensuring compliance with the probate laws and protecting those precious family relationships. In this video, we'll cover the essential steps that siblings need to follow, common legal pitfalls to avoid, and how to protect the estate assets effectively. Every day, I get a call from one of my clients where a family member has suddenly passed away. This is a very difficult time for everyone, and managing the relationships of siblings is very difficult. Patience, communication, and clarity, often all combined into the word transparency, is the missing element in most families. Additionally, all families bring the drama from previous fights, hurt feelings, and just the simple family dynamics to an estate administration. Listen, I can relate to my clients' concerns because I have a brother and, we love each other unconditionally. However, we don't always agree on everything and we live very different lives. Due to our differences on how we approach many things, we will disagree on how things need to get done. However, both my brother and I have learned how to tolerate each other's differences, and we have the humility to acknowledge that, there is often more than one way to get something done. Managing an estate with siblings isn't just about dividing assets. It's about following the legal process correctly to avoid unnecessary disputes, costs, and delays. So, what are your legal obligations as heirs? What if one sibling isn't cooperating? How do you fairly divide the property while following the probate laws? Well, here, the first thing we need to determine is whether or not probate is required. So what is probate? Probate is the court-administered process that transfers ownership from the deceased family member to you and your siblings. It provides the necessary authority in order for you to access the bank accounts and other assets that are owned by the deceased. The probate court also is the venue that ensures fairness in the estate process. Estates have to go through the probate process when there are assets, such as bank accounts, investment accounts, real estate, retirement accounts, or the like, that are just in the decedent's name alone. That means that the account has no beneficiary designated, it's not a joint account or owned by others. In this case, you need the probate court so that it can transfer the asset out of the decedent's name into you and your siblings' names. Also, if the decedent left a lot of debts, the probate court provides the venue for creditors of the decedent to collect what they are owed. When creditors go to the probate court to collect their debts, these are called claims against the estate. If an estate is properly organized with a trust or beneficiary designations or some form of joint ownership, then probate can be avoided. We always encourage our clients to plan ahead, organize their estates so their estate can avoid probate. Often, though, estates include property such as a house or land. Probate is often necessary unless there was a trust or transfer on death instrument that exists. In our other videos, we'll break down the benefits of a trust and a transfer on death instrument. However, have you ever wondered how an executor gets appointed? If the will names an executor, that person takes legal responsibility. But what if there is no will? Then siblings need to agree on the executor. And by the way, in this case, that executor's title is an administrator. And then there's my least favorite way of handling the appointment of an executor, and that's letting the court appoint one. The legal duties of your executor is to pay debts, satisfy claims, file taxes, and distribute the assets according to the will or the state law. Now that the will or the family has decided who will be the executor of the estate, it's time for the executor to open the estate with the probate court. This requires a formal filing with the court called a petition. Additionally, proper notices need to be given to all the people named in the will and any heirs of law that are different than those named in the will. Finally, in Illinois, we need to publish notice in the newspaper for any creditor of the decedent so they can come and file an appropriate claim against the estate. At this point, a 6-month clock starts to run. During the 6 months, any creditor can file a claim against the estate. At the end of the 6-month period, no additional claims against the estate can be filed. Now, what's the executor doing during the 6-month claim period? Well, the executor should be marshaling or gathering all of the assets, again, such as the bank accounts, real estate, vehicles, investment accounts, and personal property. The better the executor can document everything, the less chance there will be of any disputes among siblings in the future. In some instances, when the value of an asset can't be determined, or there's a dispute over the value of an asset, the executor will need to hire an appraiser to value the asset. This is always true when estate taxes need to be paid. We have already talked about debts and claims of the estate. All of these need to be settled before dividing and distributing the assets, and siblings cannot take assets before settling all of the liabilities of the estate. Again, the most common debts are credit card bills, medical bills, mortgages, and outstanding taxes. Failing to pay estate debts properly could result in legal action against the heirs. Remember, the executor of the estate has personal liability to get all of these debts paid. So, how do we avoid disputes? Many inheritance disputes stem from misunderstandings or lack of clarity in the estate documents. Also, all the hurt feelings from the family drama fuels the dispute in families. The more transparent everyone can be with one another, the less likely there will be a dispute among family members. If you listen to your estate lawyer and follow their directions, everyone's interest can be adequately addressed while keeping costs low. Finally, once all the debts, taxes, and other claims have been paid and the claims period has come to an end, now it's time to disperse the estate to your siblings. You will disperse the estate assets according to the terms of the will or the trust or the laws of intestacy. So if there is no direction from a will or trust, we use the laws of the state that you are in, and it's called intestate succession, and this dictates how the money will be distributed. Sometimes there are even special cases where someone wants a sentimental item or one sibling wants to keep the home. In those cases, the value of those items are offset by the distribution that a sibling would have received. Finally, it's time to close the estate. The final tax return of the deceased needs to be filed and accepted by the IRS. All the family members have to agree on the final distribution amounts. All the family members need to agree that should there be any future tax liabilities, everyone has to pay their proportionate share of that liability. You will learn more about this process by tuning into our next video, Wills versus Trust, which is better for you, by attorney Anthony Davis. But for now, know that managing an estate with siblings can be complex and emotional, but following the right legal steps, having pure transparency among family members, will ensure a fair process and reduce drama. If you need guidance through probate, estate disputes, property transfers, NTegrity Law is here to help. Schedule a consultation today. Call us at 847-802-9912. Have a great day.